Mitigating circumstances. Definition. Mitigating circumstances are those which, if present in the commission of the crime, do not entirely free the actor from criminal liability, but serve only to reduce the penalty. Basis. Mitigating circumstances are based on the diminution of either freedom of action, intelligence, or intent, or on the lesser perversity of the offender. Classes of mitigating circumstances. 1. Ordinary mitigating, those enumerated in subsections L to 10 of Article 13. Those mentioned in subsection 1 of Article 13 are ordinary mitigating circumstances, if Article 69, for instance, is not applicable. 2. Privileged mitigating. A. Article 68. Penalty to be imposed upon a person under 18 years of age. When the offender is a minor under 18 years of age and his case falls under the provisions of the Juvenile Justice and Welfare Act, the following rules shall be observed. 1. A person under 15 years of age, and a person over 15 and under 18 years of age who acted without discernment, are exempt from criminal liability. 2. Upon a person over 15 and under 18 years of age who acted with discernment, the penalty next lower than that prescribed by law shall be imposed, but always in the proper period. As amended by Republic Act No. 9344. B. Article 69. Penalty to be imposed when the crime committed is not wholly excusable. A penalty lower by 1 or 2 degrees than that prescribed by law shall be imposed if the deed is not wholly excusable by reason of the lack of some of the conditions required to justify the same, or to exempt from criminal liability, provided that the majority of such conditions be present. See Article 64. Rules for the application of penalties, which contain 3 periods. In cases in which the penalties prescribed by law contain 3 periods, whether it be a single divisible penalty or composed of 3 different penalties, each one of which forms a period, the courts shall observe for the application of the penalty the following rules, according to whether there are or are not mitigating or aggravating circumstances. 5. When there are 2 or more mitigating circumstances and no aggravating circumstances are present, the court shall impose the penalty next lower to that prescribed by law, in the period that it may deem applicable, according to the number and nature of such circumstances. Privileged mitigating circumstances applicable only to particular crimes. 1. Voluntary release of the person illegally detained within 3 days without the offender attaining his purpose and before the institution of criminal action. Article 268, Paragraph 3, the penalty is 1 degree lower. 2. Abandonment without justification of the spouse who committed adultery. Article 333, Paragraph 3, the penalty is 1 degree lower. Distinctions. 1. Ordinary mitigating is susceptible of being offset by any aggravating circumstance, while privileged mitigating cannot be offset by aggravating circumstance. 2. Ordinary mitigating, if not offset by an aggravating circumstance, produces only the effect of applying the penalty provided by law for the crime in its minimum period. In case of divisible penalty, whereas, privileged mitigating produces the effect of imposing upon the offender the penalty lower by 1 or 2 degrees than that provided by law for the crime. People v. Enriquez. Facts: the accused who was charged with robbery was less than 18 years old. He committed the crime during nighttime purposely sought, which is an aggravating circumstance. Held, the aggravating circumstance of nighttime cannot offset the privileged mitigating circumstance of minority. Note, as to whether the age 16 years or above but under 18 years is a privileged mitigating circumstance is not a settled question. Mitigating circumstances only reduce the penalty, but do not change the nature of the crime. Where the accused is charged with murder, as when treachery as a qualifying circumstance is alleged in the information, the fact that there is a generic or privileged mitigating circumstance does not change the felony to homicide. If there is an ordinary or generic mitigating circumstance, not offset by any aggravating circumstance, the accused should be found guilty of the same crime of murder. But the penalty to be imposed is reduced to the minimum of the penalty for murder. If there is a privileged mitigating circumstance, the penalty for murder will be reduced by 1 or 2 degrees lower. In every case, the accused should be held guilty of murder. The judgment of the trial court that the mitigating circumstance of non-habitual drunkenness changes the felony to homicide is erroneous. Because treachery is alleged in the information and the crime committed by the appellant is that of murder, the mitigating circumstance reduces the penalty provided by law but does not change the nature of the crime. People v. Talam. Circumstances which mitigate criminal liability. Article 13. Mitigating circumstances. The following are mitigating circumstances. 1. Those mentioned in the preceding chapter, when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. 2. That the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80. 3. That the offender had no intention to commit so grave a wrong as that committed. 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. 5. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, delito, his spouse, ascendants, descendants, legitimate, natural or adopted brothers or sisters, or relatives by affinity within the same degrees. 6. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. 7. That the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. 8. That the offender is deaf and dumb, blind, or otherwise suffering some physical defect which thus restricts his means of action, defense, or communication with his fellow beings. 9. Such illness of the offender as would diminish the exercise of the will power of the offender without however depriving him of consciousness of his acts. 10. And, finally, any other circumstances of a similar nature and analogous to those above mentioned. Paragraph 1. Those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. Those mentioned in the preceding chapter. This clause has reference to 1. Justifying circumstances, and 2. Exempting circumstances which are covered by Chapter 2 of Title 1. Circumstances of justification or exemption which may give place